Right. Good afternoon, ladies and gentlemen, colleagues. My name is Derek America, and I'm the chairperson of the Standing Committee on Mobility. Today is the 5th of March, 2024, and the matters that we will deal with today are: one, we will have a briefing of the National Department of Transport on the Railway Safety Bill. Then we have a briefing by the Department of Mobility on the Transport Appeal Tribunal Amendment Bill. And then thereafter, we will consider the comments we received on the two bills. And then fourthly, we will adopt our negotiating mandate for both bills, for that matter. And then thereafter, we will have resolutions if need be. So, before we start, could I have an indication of the members who are present so that we could, for the record, establish that we have a quorum? Members?
Good afternoon, Chair. Andrikus van der Westhuizen, member of the committee.
Yeah, hello.
Good afternoon, Chair. Mbulela Isaac Sileko, member of the committee.
Thank you. Any other members on the platform?
Afternoon, Chair. My name is Nomin Kondlo. I'm an alternate to the committee.
Good afternoon, Honorable Nkondlu. Anybody else?
Good day, Peter de Villiers here. I'm a member of the committee. Sorry for being late.
All good. Afternoon, Honorable de Villiers. Any other members on the platform? Okay, thank you. Johan, do we have any apologies that you may be aware of?
Chairperson, no apologies received.
Good. And then we also have for support staff on the platform, and that is Ms. Mashumpela. She does the secretarial support for the committee. We have our IT support staff on the platform, Mr. Hassan, as well as our procedural officer, Mr. Johan Kutsia. And then, ladies and gentlemen, we further have numerous members of both the Department of Mobility as well as that of the National Department, but certainly I will give them an opportunity to introduce themselves shortly. Safe to say that this meeting is conducted via the MS Microsoft Teams platform. Unfortunately, we do not have interpretation services available, but if need be, we will always make a plan. This meeting is also transmitted live on YouTube for members of the public and other interested stakeholders to follow our proceedings. At this stage, I need not to reiterate our rules of engagement. I think all members and our guests on the platform are very familiar with the MS Teams platform. Safe to say that we will indicate whether we wish to make a contribution to the topics under discussion, and I would urge all participants and guests on the platform to switch off their microphones when they finish speaking, and for bandwidth purposes, if need be, just to disable the video function once they have completed speaking, and they may use it or may not use it. So, ladies and gentlemen, I am very mindful of that 2 of our members are in transit from George, so they may experience connectivity problems along the way, but certainly when that sort of occasion arises, we will deal with that. So, that said, so I'm going to hand over to the Department of Mobility. I don't know if the Minister is on the platform. Minister Mackenzie, are you on the platform?
Yes, I am. I'm Chairperson. I'm here.
Good. Oh, I see you.
Yes, I am.
Welcome, Minister, and welcome, Ms. Moore. And maybe you can just introduce your team that you brought along to this meeting.
Thank you very much, Chairperson. Apologies, I'm just logging on from another laptop. My laptop is restarted Murphy's Law at the same time. It was 5 to 1. It just restarted by itself. Update. But good afternoon, everyone. My name is Ricardo Mackenzie, Provincial Minister of Mobility, and thank you for the invitation, Chairperson and members. And I'll hand over to my head of department, Ms. Marissa Moore, who's here with the rest of the team to introduce themselves as well. So you can also hear their voices and see their faces. Thank you, Chairperson.
Thank you, Minister. Hello, Ms. Moore.
Good afternoon, Chairperson and members. Just my team who will be joining us this afternoon, my Chief Financial Officer, Mr. Francois de Wet is here. The Acting Chief Director, Ms. Bernie Mahon is here. There might actually be some more people from her team joining. And then from our policy and research team, Mr. Mario Brown is here with us this afternoon. And also from transport operations responsible for freight is Ms. Corinne Galant. Thank you, Chair.
Thank you, Shudi. Thank you, Minister. Then we also have the National Department of Transport on the platform. I don't know who they are. Who's leading the delegation?
Good afternoon, Honorable Chair, Honorable members. My name is Mwaku Makaipia. I'm the Deputy Director General responsible for rail in the Department of Transport. I have my colleagues on the call from the department. I have Ms. Muluko Machaka, who's on the line, and from the Railway Safety Regulator, we have Ms. Kolisa Shiburi. Thanks very much, Chair.
Thank you, Mr. Mapuepa. And then we also have our state law advisors from the Department of the Premier. Can they introduce themselves, please? They're on the platform.
Good day, Chair. It's Astrid Miller from Legal Services, Department of the Premier, Western Cape Government.
You're welcome, Ms. Miller. Are you the only one from the Premier's office?
Yes. Good afternoon, Chair, and everyone else present. Shanaz Seria here, Department of the Premier, and I am particularly interested in the Transport Appeal Tribunal Amendment Bill.
Thank you, Advocate Seria. And then we also have from the Parliament, Legal Advisor, Western Cape Parliament.
Afternoon, Chair. This is Mpho Kwele. I'm providing support to the committee with my colleague, Ms. Saskia Peters.
Thank you, Ms. Kwele. Any other person or that maybe on the platform that we're not aware of, that haven't introduced him or herself? Seems that, okay. There we have Mr. Collins.
Good day, Chair, and good day, members. Ricardo Collins from the Transport Operations Branch. Thank you.
Thank you. Welcome, Mr. Collins. Anybody else that we've sort of missed? Okay, thank you. That seems to be everybody on the platform. Once again, a warm welcome to all our guests and members on the platform. And I'm sure we're going to have a very engaging meeting this afternoon. I may add that our colleagues who are on the road have connected via, a device that may limit their participation in the meeting. I certainly am very conscious of it, and I'm sure, we will deal with whatever difficulties you may experience as far as connectivity is concerned as we go along. So, as we were saying, that once again, we're going to have a briefing by the National Department of Transport. They will brief us on the railway safety bill, and may I once again express my heartfelt apology to those members who have only received the presentation today. It's a situation beyond our control. Needless to say, we are here now and we have to deal with it. So, Mr. Pia, I'm going to hand over to you so that you could direct as to how we're going to do it and who's going to do it. Thank you, Mr. Mapepa.
Thanks, you, Chair. I can hear you. You are finding difficulty in pronouncing my surname. It's Makaipia, Chair.
Okay, Sevakapia. Okay, certainly, sir. Thank you. We can see the presentation, and we may proceed.
Yes, Chair. I'll be the one doing the presentation on behalf of the department. And just to say, we have joined by additional members on the team. We have Mr. Freddy Khomari from the RSR and Ms. Fulufelo Chidada from the Office of the CEO in the Railway Safety Regulator. And once more, let me greet the Honorable Chair, Honorable members of the committee, Honorable MEC Mackenzie, and all the colleagues from the Department of Mobility, led by the HOD, Ms. Marisa Moore. When we really appreciate the opportunity to come and brief to the committee on the railway safety bill. Moving to the next slide, Chair. Just to provide the background is that the railway safety bill seeks to repeal the current legislation that is regulating railway safety in the country, which is the National Railway Safety Regulator Act. You will understand that the legislation was promulgated some years back in 2002 with the establishment of the Railway Safety Regulator, and later in the years of 2009 based on some of the developments to make that legislation implemented easier. And currently it is this legislation that is that formed the RSR, which is an independent entity to oversee railway safety. As part of the work that we do in the department over the years, we normally look at our legislation, whether that is still really achieve the kind of intended objective that it was promulgated for. And we therefore, as the department, conducted what we call a railway safety regulated gap analysis to really look at this founding legislation, which is the National Railway Safety Regulator Act. And as part of that process, we really found some legislative gaps, considering this was the first legislation to establish the railway safety regulator. Among those were lack of clarity on the role of various players within the railway safety environment, especially those that are for the regulator and those that are the operators. And within the environment, there were some duplication of powers between those of the CEO and the board. And we, over the years, with some of the developments, we found that there were some funding requirements based on the work that the regulator had to do, that didn't have some legal instrument for us to be able to cater for that. The other finding was really the absence of a framework that regulate a licensing of the safety critical grades employees, which are those employees that consist of those that are responsible for the signaling and the movement or in the movement of trains and your train drivers, and some of the lack of appeal of proper appeal mechanisms, especially on those decisions that are taken by both the CEO and the board in order to avoid the operators going towards court. What are the additional mechanisms that you can be able to indicate? And lastly, how do we then separate different roles of responsibilities within the occurrence investigation in terms of what becomes the role of the regulator, the role of the operator, and those of the department at an overall level in providing for the regulatory tools to deal with this matter. Moving to the next slide, which is slide number 3, Chair, is really to then say that the Railway Safety Bill seeks to repeal the current National Railway Safety Regulator Act. Like I said, it was developed in 2002, amended in 2009, and when we then dealt with this exercise, for us to provide greater clarity, we felt that it was important that we then develop a new bill so that it becomes easy to read in terms of reference. And at the high level, the bill really ensures a regulatory framework that develop those roles and to ensure that rail becomes a preferred mode of transport, and there's a real issue of safety within both passenger and freight operations, and to ensure that the regulator itself plays its oversight role and the operators are able to play their role in that regard. Moving to the next slide, which is really about our problem statement in terms of what we seek to really solve in this legislation. We want to bring to the attention of honourable members that over the years, the railway sector has gone through some developments, especially your major railway improvements and investment. To name few, it's the introduction of standard gauge network in the Gautrain environment, which really posed some challenges within the railway safety regulator in terms of how do we manage that in terms of the reviews that we need to do, the kind of rolling stock that is coming into the environment. And secondly, Chair, can I continue? I hear there was somebody raised an issue. I hope it doesn't concern the presentation. Secondly was really the Prasa modernization with the Gibela factory and the trains, where some of the safety critical employees who were not trained in this country, and obviously how to deal with that. And lastly, the TFR locomotive program with the Chinese counterparts. These are really some of those key programs that the regulator has found very well, and we are trying in this current legislative bill to make sure that we bring that and be able to then address that. One of the last element is really the railway safety regulator is governed in terms of their legislation to annually produce what we call a state of safety report, to really look at the health status of our railway industry. And over the years, some of the issues that came out of there was really a rail accident, which were really due to human error, where you find drivers passing the red signal, and at the same time, lack of training within the safety critical grades employees over the years, that they were not able to really perform some of the refresher courses in that regard, which has really created to that. And in this bill, we seek to really address those particular issues. Moving to the next slide is talking to what are really the objectives of the bill. The bill at a high level still retain a number of elements of the Railway Safety Regulator, National Railway Safety Regulator Act, but what we are doing is really providing clarity on a number of issues and introducing a new concept to enhance railway safety in the country, especially dealing with the issue of safety critical grades. How do we deal with the railway safety inspectors and really expanding on those powers that needs to guide them in doing their work, whether you are talking about routine inspection in terms of the audits that they need to do, or where they must go beyond the call of duty when they suspect that there is some compromise within the railway environment in line with what has been submitted in terms of the safety management system. It really, one, recognizes the role of operators in managing, implementing safety within their environments, and how do we then make sure that we promote railway safety through an improved regulatory framework, reinforcing that in terms of some of the standards that we seek to introduce, and secondly, the regulations that talks to that. And the bill, from where we posture it, we make sure that, one, it must promote rail as a preferred mode of transport, and positively contribute towards the economy of the country, because we know, even with the state of safety report, the issue of safety, one, of passengers in our railway environment, both commuter and rail, it has been raised by our stakeholders, and secondly, within freight, to make sure that those freight that we transport move freely and safely towards their destination. So the kind of technologies and the mechanisms that we introduce as part of this bill and the regulatory tools, we believe it will be able to assist us to achieve to that. Moving to the next slide, which is really talks to the approach, is to then say the approach really focus on rail safety and provide an enabling framework. And we have revamped our section that deals with governance in terms of the board, that we have made sure that it really complies with the DBS guides for appointment of persons on board and CEOs, especially in terms of state entities, and really introduce those clauses that seeks to make sure that it provides clarity and there's no gray area in terms of the directors being able to dispense their fiduciary duties in that regard. Moving to the next slide, which is on clause 4 of the bill. Clause 3 of the bill, which talks to the object of the bills. It really talks to how do we enable operators to undertake safe railway operation in terms of introduction of the regulatory tool, and to facilitate a modern and a flexible regulatory regime to ensure we continue with including tools like NIMS in terms of the legislation, and how do we make sure that the regulator continue to collaborate with all affected parties to improve safety. One, within the organs of states, which will be Department of Labor, Department of Police in terms of sharing of statistics. But again, how do we work with the industry in terms of various standards to be able to make sure that we deal with these issues? And last, and obviously second last, how do we then promote harmonization of rail safety within the Republic and within SADC? The honorable members will know that within the railway safety environment, those that are permit holders that the RSR manage include some SADC operators from Mozambique and Botswana, where they get the permits. But the regulator plays a very important role to make sure that there is harmonization within the region, and we have played a role in terms of a regional rail safety body to ensure that whatever elements that we introduce in the country are able to be adopted within SADC, and we can be able to have same standards when we cross the borders to ensure the areas of interoperability. And lastly, how do we ensure that the coherent governance applies within the Republic as a whole, especially amongst the role players, which is your operators, suppliers of equipment, and those that supplies infrastructure. And how do we then do this with various interested parties to make sure that the railway safety regulator gets into memorandum of understanding of cooperation moving forward. Moving to the next slide in terms of the application, that the general application of legislation really remains unchanged in terms of it applying to those railways that are designed to transport or do the operation within freight and passenger operation within the Republic. And obviously, clarity on some of the concurrent application where it doesn't apply in terms of the amusement park and within the mining area. Moving to the next slide, which is slide number 9, it really talks to these elements of governance, which if you look from the previous, the current legislation to the clause, we have really provided more clarity. In terms of clause number 5 of the bill, RSR continues as established as an independent body that talks to and responsible for rail safety within the Republic. The object there of the are really and function are listed, largely unchanged, but providing a better clarity. The powers of the RSR are therefore clarified now into those that are mandatory and discretionary, which are the must that they must be able to perform, and those that may perform, obviously with collaboration to the industry, and how at a high level they administer international agreements in terms of the Republic, especially with those countries that we have bilateral relationship with. Because when we formed the rail safety regulator, there are those countries that we have worked with, benchmarked kind of the regulatory tools, and we continue to do that, but obviously aligning themselves to the country itself in terms of where we really need to deal. Moving to slide number 10, we talks to the governance element, especially starting from clause number 9 to 20 of the bill, where one we talk to the nomination process of the board, in minister appointing the members, who majority must serve as non-executive executive members. But the bill are able to allow for those critical members from who must represent government at the shareholder, being the Department of Transport, the police, with the collaboration of that we want to have, understanding that there is a clear relationship between safety and security, and how we collaborate with them in terms of the statistics, and the Department of Labor in terms of the work that we do. The term of office being very clear that it is a maximum of 3-year term, which is renewable, and the directors can serve 2 consecutive terms. And we are saying a majority of those must be non-executive members, and a clear disqualification criteria is therefore clarified as part of the legislation. Moving to slide number 11, Chair, in terms of clause 22, it really talks of a process of the appointment of the chief executive officer of the regulator, which is a process that is run by the board, and recommendation to the minister in terms of the approval process towards coming in and saying a clear, obviously more than one candidate being recommended by the board for that appointment. And we are providing a strong ministerial oversight and extended dismissal provisions to make sure that the board itself and the directors able to take their fiduciary duties serious, to ensure that there is a clean and clear qualified audit, and obviously providing that if there's a good cause, the minister might be able to dissolve the board, obviously following a clear administrative and just administrative process. Moving to the next slide, number 12, which talks to what are those governance tools that the minister and the board needs to enter into in able for them to do their job. One, clarifying that the board must annually conclude a performance agreement in terms of their targets, aligned to the targets of the regulator and the APP in terms of the work that needs to do, and continuously the provisions of how do we deal with board evaluation to look at their performance, and to ensure that they lead management in terms of how they discharge their role in terms of safety, the process of clear recusal of a case of conflict of interest, so that there's no gray area, especially with the lessons of that we have learned over the previous years of the government breaches that has happened in state entities, and the functions of the board are clearly listed on how do we then continue. Moving to slide number 13, still dealing with the issue of the board on how they need to govern themselves. Obviously, dealing with the board committees that they need to deal with that and their role in appointment of the appointment of the CEO. One of the critical elements which came out in slide number 14 out of the gap analysis that we have dealt with was really those funding instruments of when the new elements are and operations are coming into the fold. How do we really make sure that the funds of the regulator are able to deal with some of those requirements, considering that when the regulator initially established was funded mostly by government, but over the years we have found that there is some kind of attention that the regulator needs to really pay attention, and we have covered that, one being the funding streams of the regulator in clause 27 of the bill, the money appropriated by Parliament, which is a grant that we transfer as the Department of Transport, and the fees specified in terms of section 66 of the bill, which is the permit fees that they pay to the regulator, and there is a clear process currently done in terms of section 23 2A and B of the National Railway Safety Regulator Act. Then levies, if they need to be imposed through the money bill with the Ministry of Finance, and it's some of those mechanisms that are implemented in the regulatory environment in SAMSA, that is, and the aviation sector. And lastly, any other fees of source of income provided by the legislation, especially what we call specialized services. For example, we are going now into a situation where the National Rail Policy has approved the implementation of third-party access where we'll be having operators getting into the network of the current infrastructure manager. And with those new operators, some might not even come into this country. How do you make sure that the technology that is improved there? So RSR will have to deal with those particular elements. So we really need to, but just to give comfort to the honorable members and chair, is that the RSR doesn't make any profit in terms of the fees that they collect. They design their APP based on that. They then trigger the fund of source of and whatever amount that they don't use, they then take it back to the fiscals. And now what we have even introduced is that one of the elements that they'll connect is the issue of penalties. But when those penalties, they charge them, the money goes back to the National Revenue Fund, as opposed to it being kept by the Railway Safety Regulator. The next clause really talks to issue around safety permits, which is a critical element because it is an offense for any other person to undertake a railway operation without a permit, and this is applied through the Railway Safety Regulator. And we will see that we have provided for the categories of those that must be able to get the permit, one being train operator, for somebody who can be able to run their own train operation, or a station operator, a network operator in terms of infrastructure. And we have added another element which was not there previously, the concessionaire, especially based on the development that has happened over the years, Gautrain being one example, and some of the pronouncement that has been made by the railway safety operator. The e-operator, the RSR, provide a prescribed way in terms of how this regulator must be able to be applied upon through the permit fee regulation, and how the process are submitted through the National Information System. Moving to slide number 16, to indicate that in terms of the funding element that I've talked to, that even though the permit might be over the number of years, but for the operations of the annual operations of the regulator, the permit, the safety permit fee must be paid annually in terms of the period validity, and obviously the regulator, after considering the application, if they'll specify, obviously, one, the period validity of the permit, which is 3 to 5 years, or any other conditions that they need to add based on if there's any condition that needs to be added to that. It's very clear that the operators in this regard, and we put it in the legislation, the next slide 17, that there might be conditions of that will be attached to the permit. There are standard permit conditions, and obviously those that will be introduced based on the risk. And this permit, when you have applied for it, is really non-transferable, and there's a clear reapplication process of 3 months prior to it being expiring. And then obviously there is a clear process that we have put now under which conditions you'll have to surrender. If it felt that you are not safe, the regulator can be able to suspend your permit. Moving to slide number 18, it's really talking to safety critical grade, which is a new element that we are introducing the bill, which has not been in the previous legislation, which was as a result of the Board of Inquiries that we have conducted, and the gap analysis, where we are then saying those people that are responsible for authorization of rolling stock, including train controllers, those that are responsible for signaling, the train drivers, must be really have a governance framework. Because if you remember previously, when there is train accident, both the railway safety regulator and the government is asked, and we might not be able to answer some of those questions. So this management of a prescribed framework for safety critical grades will be introduced, where those that register training institutions and licensed safety critical employees need to register with the railway safety regulator. We know they collaborate with TITA, but we want to play a role in that curricula so that it reflects the safety requirements of the country based on the work and the research that the RSR do, so that the RSR can then keep a database and of those safety critical license holders, so that in case of an incident or any other matter, we'll know whether those people belonged to our have been cleared by the regulator, like it's happening within other safety environments in maritime and in aviation. And we are saying no person may perform a safety critical grade unless she's in the percent of this safety critical license granted by the regulator, and the required refresher courses over time. Over time in the railway safety environment, in the next slide, we really talked to the rail safety standard, which are those standards that guides the regulator in doing their work. One is that they are either introduced by the regulator itself, but together with the industry, if they believe that there is standards that are critical for the sector, they therefore are able to introduce and submit those standards to the regulator to be able to consider. And the bill really provide a clear process on how to deal with that minister might notice in the Gazette prescribe the railway standards that will be applicable to the regulator, which is the regulator standards. And the regulator or any operator might propose railway safety standards. But obviously, prior to dealing with that, we must be able to make sure that it is a transparent process. And how do we make sure that the public is consulted and the operators in that regard? But again, how do you then incorporate those high-level standards, which the standard body being the SAB have developed, and how do we cooperate with that, and the kind of regulations that we deal with are able to then incorporate that. Moving to slide 20, which is clause 37 of the bill, it really talks to the safety management system, which is a critical document that the operator compiles in the application of their permit, so that they are able to detail the kind of operation that they are going to embark on, whether it's dangerous good, it's normal operation, is it passenger, is it freight, how are they going to deal with their movement of train, and the safety protocols, including the security plan. that they'll be able to deal with those. So they then determine that. But what we then say is that the board of the regulator must be able to determine what then becomes the form and the content, because we believe over time, depending on the requirement, this might be able to change, and the board over time must be able to evaluate whether the safety management really deal with that. After dealing with, there must be a consultative process. They must publish it, gazette it, and at the same time be able to put it on the board of the regulator for the regulator to be able to do their work. Moving to next slide, which is really dealing with the issues of enforcement, especially in terms of slide 21, which is our railway safety inspectors, which is clause 42 of the bill. We have really clarified a process where in clause 41, how the inspectors must be able to deal with their audits, and what are those powers that are routine inspection and enforcement inspections, especially starting from clause 42 to 46, which we have amplified the previous section, which was not in terms of the current legislation, and how the process of appointment. And we have really, as government working with the railway safety regulator, have really formalized the qualification of railway safety inspectors, that we have collaborated with the University of Pretoria to produce a qualification that they go study, so that really there is intense work that is happening in that. And obviously, how do we allow them to deal with immediately with unsafe situation where they can be able to have on an authority of a warrant, can be able to enter any railway environment to do the inspection or stop any operation in that regard, and some clear guideline of what then becomes the role and the responsibilities of operators when there's an incident where they must not be able to remove any evidence, they must stop operation, and they must be able to make sure that they inform the regulator immediately within 24 hours. The next slide, which is slide number 22, talks to the issue of railway occurrence and investigation. Remember, in the current legislation, the railway safety regulator will be the one that does the board of inquiries and the investigation, go and oversee whether the investigations are implemented. And again, if you are not implemented, they then issue the prohibition notice or fines in the form of penalty. So we have really clarified this section in the bill to make sure that we then separate what then becomes a major investigation, a standard deviation, and then obviously a commissioning inquiry in extreme cases. And we therefore obviously say the minister will be able to prescribe through regulation the kind of investigation that must happen, and what then becomes the role of an operator in terms of securing the scene of the risk of an occurrence, preventing the movement, and recording the names of all those people to be able to provide evidence. And a major investigation in this regard will be conducted by an independent investigator appointed by the minister, and the railway safety regulator will provide inputs into that. But at the end of the day, what then becomes a requirement, they'll be able to assist. Standard investigation conducted by the operator themselves, with the clear guidelines that will be provided by the railway safety regulator, because this is one of those elements that we have found that it was costing the regulator in terms of really resources to be able to deal with that. And lastly, a commission of inquiry in case of extreme circumstances. Moving to slide number 23, which is in clause 54 of the bill, is really respond to the issues that have been raised by our stakeholders, but secondly, issues that came out of the gap analysis about how do we make sure that we provide for extended appeal mechanisms beyond the decisions of the board, to make sure that the operators don't move to run to courts, and what we have provided here beside appealing the CEO of the decision of the CEO or against the decision of the railway inspector, from there moving to the board. Now there's an added element of the transport appeal tribunal against the decision of the board, which are independent people to be able to make sure that we deal with those particular issues. And there is already capacity that exists. We just have to add in terms of that particular regard. Moving to slide number 24, it talks to clause 63 to 65 in terms of those general powers that empowers the minister to make the regulation, but to then caution that those regulations must not be a burden to the operators in terms of compliance, and a clear analysis to really make sure that there is a balance towards that must be provided. But what we have done in this bill, one, because of the inputs that we have received from especially tourist operators and those that are traditional rail operators, we have provided for an exemption clause in the beginning of the clause to make sure that there is a representation that are made to the minister to be able to deal with those particles. Moving to slide number 25, is really about those regulations that will be developed to ensure an impact in terms of implementation and the detail of the bill, which is a regulation really regarding the design and construction of new operations, regulation regarding movement of infrastructure, rail occurrences, those regarding fees, those regarding the safety critical grades as the new elements that we have provided. In terms of consultation, in slide number 27, Chair and honorable members, we have consulted across in terms of the bill. Initially, when we publish it for comment, we have consulted organized labor, had a consultation with workshops across all 9 provincial departments. We have, and again, the broader public. We have talked to the railway operators, TITA. We have then submitted it even to the National Assembly with those process and participated in the process. And then we have went through NETLAC process and all those kind of. In conclusion, Chair, honorable members, we believe that once promulgated, the Act will really lead to significant safety improvement in the rail environment, even though there might be additional minor cost introduced. We believe that, but the benefits that are to be derived will far outweigh the cost, and it will make railway as a mode of transport to be one of those preferred mode of transport, and is a mass mover, is a clean mode of transport. And the risk related to implementation will be addressed through a national rollout session, through the railway regulator and the department to ensure that there's clear change awareness management process and buy-in with regard to relevant stakeholders. With that, Honorable Chair, honorable members, let me thank you. That's the end of our presentation. Thank you very much.
Thank you, Ms. Makai-Pia. Sorry. Thank you, Mr. Makai-Pia. Much appreciated. We will now open the floor for questions of clarity from the members, and thereafter from any other person on the platform would like to ask a question of clarity. I recognize Honorable van der Westhuizen. Honorable van der Westhuizen, you may proceed.
Thank you very much, Chair. Thank you for the presentation. Chair, I would like to get the department's response to 2 issues. The first one is, when people view the safety of our trains and particularly our commuter trains, their biggest concern is not safety of design, etc., but passenger safety from a criminal point of view, criminality, petrol bombs, the environment of our stations that are deemed to be dangerous areas where no, self-respecting person should go, and where those that are concerned about their safety should avoid. Now, my question is just, would I be correct in saying that in reading this legislation or this proposed legislation, that the focus is on safety from a railway accident, railway design point of view, and not from a point of view where passengers' general safety is being addressed or looked at? The second point is in terms of the work of the safety regulator, and I'm going to be a bit cynical. It's the very same minister responsible for railways that will also be responsible for the budget, etc., of the safety regulator. So to what extent can we expect the regulator to take an independent view and therefore, close certain sections of railway or, stop certain trains when they deem it to be dangerous? Should, for example, they then jeopardize their own budget or the image of the Minister of Transport? Those are my two questions on which I would like a response from the department. Thank you.
Thank you, Honourable van der Westhuizen. I recognize Honourable Seleku. Please proceed.
Good afternoon, Chair. Once more, my apologies. Maybe I was commuting. I might have lost some of the information on the presentation. But Chair, mine is just one. I think I would like the presenter just to talk more about the appointment when it comes to the issues of governance and the boards. How does this particular bill address the issues of people that will be serving on these governance structures, and to make sure that they are not politically influenced and that it is actually people that are competent enough to do the work that is expected, and we are able to reach the objects of this particular bill, because we have seen in the media, we have read, everywhere in terms of one of the issues that actually contributes to the unsafety of our passengers is actually the people that is supposed to play a role in making sure people are safe. And then if the bill does not address the appointment of such individuals, that must make sure that whatever needs to be done by this particular bill are people that are competent enough, then this particular bill is not going to achieve any of the things that it actually wants to achieve. So I would just want to know more about how does the bill actually address the issue of appointment and make sure that whoever is going to play a part or a role in this particular bill is actually someone that is competent, but not a cadre that is just there to milk the state of resources. Thank you very much, Chair.
Thank you, Honourable Seleku. Anybody else would like to pose a question for clarity? In the absence thereof, could I ask Mr. Makaipia if you'd like to respond to those initial two questions?
Thanks, Chair, and thanks to the Honourable Member. The issue of safety, there is obviously the Railway Safety Regulator deal with safety issues within railways. But what it does, like I said, that's why we even have the police as part of the board of the regulators, that we understand that there is a relationship between the two. And the safety regulator, when you apply for what I call a safety management system that I've talked to, wants an operator to have a security plan that they submit as part of that, which include measures to protect people from theft, assault, and other criminal acts or other parties of harm. And obviously, if you are able to then have a systems and procedures in your SMS that ensure that there is safety critical railway assets are protected from theft and vandalism, they are able to do that. And there is a clear collaboration in terms of that particular element. So security obviously the responsibility of the Minister of Security, but the Act itself made sure that the passengers themselves feel safe. So it goes beyond the systems, but it talks to people itself in terms of the role of the regulator. Because part of what you put in the SMS includes how are you going to deal with safe operation in terms of the work that you do. So it does include issue of general safety across the board. And whether to an extent that, I mean, the Minister of Transport, yes, is responsible for rail in the Republic, honorable member, but you'll remember that out of the 250 operators that you then have, that the railway safety regulator is responsible for, is probably two big ones, including which is Transnet and Gautrain, which belongs to government. But where we come from is that the department, the regulator, has continuously exercised their duty where they really find out that the operators have not been able to do their work. And we have seen previously where PRASA, for example, when they submit their permit, instead the regulator couldn't give them a long permit because of some of the safety elements that they've identified. So we believe the regulator, as a creature of state, they'll be able to really provide an independent view in dealing with that, because the accounting officer of the regulator then becomes of the board of the regulator. So I think we believe that we are fine in that regard. The Honorable Seleku, in terms of the issues that we have raised, if you look at board clause 10 of the board, obviously starting from clause number 9, we then talk to the process in terms of the board supposed to be individual members who must be independent and must conduct themselves at the highest applicable standard and ethic of governance, so that they then promote the interests of the company, not their interest. And like the process of appointing that board becomes a very transparent process where there is advert that goes out and there's a clear process of how do we make sure that those that comes there and are appointed obviously are fit for purpose. And we are even saying that must be gazetted in terms of clause 11, and it must be even within the newspapers. And we're adding clause number, if you look at clause 11.5 of the bill, we're saying minister must within 30 days from the date of appointment notify Parliament of such appointment, and the department must even publish it, that if there's any objections, that members of the public can be able to do that, must be able to deal with those particular issues. So we believe, and if you look at clause number 10, we then even talks to the skills that are needed there. There must be people who are in management of railways and understand operation. There must be engineering within the rail environment, understand corporate environment, and all those kind of things. And I think the honor is really, those are discharged with these responsibilities to make sure that they're able to deal with that in a very transparent and open. Like I said, we have learned as government some of the governance breaches that have happened over the years, and I think we seek to make sure that when we assist the minister in discharging their responsibility, there must be a clear process to deal with that. Thank you very much. Those would be how I'll really respond to the questions. Thank you.
Thank you, Mr. Makai-Pia. I see Honorable van der Westhuizen's hand is still raised. Is that a new hand? Or is it a legacy hand, Honorable van der Westhuizen? Be able to hear me, Honorable van der Westhuizen? Is that a new hand or old hand? I take it it's a legacy hand. Any other questions, members?
Sorry,
would like? Please proceed. Okay.
No, I'm sorry. It is.
No, I understand. Thank you. Thank you so much. Are there any other questions for clarity that members would like to pose? Anybody else would like to pose a question for clarity? See, Miss Cooley, I recognize you. You may proceed.
Thanks so much, Chair. Chair, I have questions around the content and the wording of the Act itself. Chair, with your permission, could you flight the bill for us, please?
Jan, are you able to do that, Jan?
Could you do it on your side, Chair?
Eh?
Could you do it on your side, Chair?
No, I don't have it with me here now.
All right.
Jan usually does that.
All right.
Okay.
So I will briefly read out the provisions that I think are a bit problematic in terms of lack of clarity or particularity or ambiguity. In terms of section 9.2, it says, the title is Board of Regulator. Yes, that's it. It says the board must oversee and exercise general control over the performance of the regulator to ensure that the regulator, as far as possible, achieves the objects referred to in section 6. So I have a problem with those words, as far as possible, because they are not clear enough in terms of the metrics that will be used. Like, let me give you an example. If we are to go to section 6 itself, so do the words of that provision, as far as possible, mean that in 1 year, in one financial year, if the regulator promotes, regulates, and reports on safe railway and railway operations, if they are able to achieve this objective or this metric, and that is as far as possible what they're able to do within that year, will that be sufficient in terms of the Act? So, you know, for me, there's a lack of clarity there. And then if we can go back to section 9, and we'll look at section 9.4. So they say that the board and individual board members must conduct themselves in accordance with the highest applicable standards of ethics and governance. So my question is around the words highest applicable standards. I'm unsure of which standards exactly are they referring to. Are they referring to the King Code, or, you know, there isn't a particularity with those provisions? So that's just my question, Chair. Thank you.
Thank you, Ms. Cooley. Mr. Makaipia, if you're able to respond to that particular question, I'll appreciate it.
Thank you, Chair. And to the colleague who raised, I don't know if the honorable member, Chair, just to talk to the issue on section 9.2, is that you want the board to be able to do their work beyond the call of duty. And I don't think we must read that section in isolation, because if you go to the section on the board, that's clause number, where the board itself, it have tools that on annual basis, they must be able to complete a performance agreement with the minister. So it can be on annual basis only, because the regulator itself obviously exists beyond that. So there are those tools that are put in there for us, for the board to be able to do their work. So in our understanding, we believe that really it's a way of how do you go beyond really reproach to be able to deal with that. So that won't really be sufficient. And I think it's something that you can measure in terms of one in that section, because, for example, if you go into the bill itself, there are a number of regulatory tools that are therefore the board will be judged on in terms of dealing with that. One, they must be able to determine the form of the content of the safety management system. They must approve a framework of safety critical grades. So there is number of those elements, including that performance agreement that I've talked to, which really talks to in the current, because it must be based on the current current circumstances, what will be the key element that the regulator must be able to deliver on. To give an example, over the previous years, you'll find that the focus of the regulator was really more on the development of standard and the regulatory tools. But now with the introduction of the third-party access in the network, there'll be a different focus of the regulator. So it's really within that context. And then the second one on 9.4, why do we then talk to the highest applicable standard? Is that legislation for us, how we put it is that is not developed for today. It's for the future. It's year to come. You can just imagine if we were to specify that we are talking about the King Code 4, for example, or we are talking to the guideline of appointments of board by the public service. I mean, the King Code itself has gone through a number of amendments over the years. So if we stay Scheme Code 4, 3, or whatever we put there, or the governance, what then happens when that kind of a code? So we must go back now and be able to amend the legislation. So it is those high applicable standards that of ethics and governance that exist at that particular time. Hence, we'll even go in this bill and talk to what will be those issues that will conflict, will disqualify the members, and the issue of conflict of interest in that particular element. So that's how, Chair, I think I want to provide clarity. You don't want to keep on going to amend the legislation based on specifics, but because we know how companies work, they don't work in isolation to some of the applicable legislation and governance within corporate governance environment. Thanks, Chair.
Thank you, Mr. Makayipia. Ms. Kule, you'd like to pose a follow-up question, or is it okay if we proceed? You satisfied with the response?
We can proceed, Chair. Thank you.
Thank you for the question, and thank you for the clarification, Mr. Makayipia. I have not a process question, Mr. Makayipia. Obviously, a lot of work has gone into this particular bill and to get it thus far. So what we have on our program is that we need to form a negotiating mandate for our NCOP delegates. But the NCOP will only consider the negotiating mandate on the 27th of March. Now, that is also the date that the NCOP will then go on recess and then return sometime in April. And then we know, obviously, the congested process that will follow thereafter due to the elections. What would be the chances that this particular bill will be approved in the 6th Parliament? Because the tribunal bill will be given the allocated times. If you have any insight, perhaps, in terms of when the final mandate would be required because we also going on recess, and we need to program such a eventuality. Thank you, sir.
Thanks, Chair. Chair, what I can say, I think from our side as the department is that we have gone a long way in doing this work, and it will have been our preferred approach that before the Parliament closes its business, the bill it's really dealt with in terms of those processes, but I can't comment on the process of the NCOP. I mean, it's not within us, but that's really what I can say. Thanks, Chair.
Thank you, Mr. Makaipia. Colleagues, one last round for possible questions for clarity or anything, any comments you'd like to make? Well, in the absence thereof, may I take this opportunity to thank the officials from the National Department of Transport for providing us with this presentation, and it will certainly guide us and inform us in terms of the process that we need to follow, and also it will sort of, in a way, also assist us in formulating our negotiating mandate. I'd like to thank Mr. Makaipia for the presentation. I know it was long, but you did a very good job. And for all the members and our legal advisor, Ms. Kuile, for the questions you posed. And certainly, I hope that we were reasonably satisfied with the responses that we've gotten. So thank you, sir, and thank you to your team. And that brings me to the third point on the agenda, colleagues, and that being we will now have a briefing by our department, the Department of Mobility, on the Transport Appeal Tribunal Amendment Bill, and well as the Railway Safety Bill. I know that it's a fairly long presentation, Ms. Moore. I don't know if you want to, particularly the Road Safety Bill, I don't know how you're going to deal with it, but I'm leaving it up to you to decide as how you're going to deal with it. Over to you, Ms. Moore. Thank you.
Thank you, Chair. Firstly, I was thinking maybe we start with the railway safety amendment so that it's now fresh in everybody's minds. I have asked the Director for Research and Policy if he would take you through our comments, and I will also ask that he does it in a timeliest manner. Mario, can I ask you to take the committee through?
Thank you so much, Ms. Moore.
Thank you, HOD. Thank you, members and colleagues. I'll just put my presentation on.
Thank you.
Loading.
We can see it. Thank you, Mario.
Okay, thank you, HOD. The purpose of this presentation is basically just taking National and the members and our colleagues here through some of the comments that we as a department made, and also in terms of the comprehensive comments that we received or that was received by legal services. So just in terms of the general comments, the first issue that we've identified there, the need for refined legislation on the railway regulator. Then also the roles and responsibilities pertaining to certain issues that we've also highlighted, like crime, vandalism, overcrowding, lightning, communication, security personnel. Then also in terms of, we look back in terms of the white paper of rail policy of 2002, they should also make provisions for the devolution of rail as per that specific rail policy of last year or the year before. Then just a question for National. In terms of this bill, was the socioeconomic impact assessment done? If it was done, could you please provide it for us? Then I think this question also speaks to one of the questions that was posed earlier in terms of safety of passengers, that the bill needs to reconsider to speak to this. We've also highlighted a few issues within the comprehensive common documents that will be provided to the national government. Then just continuing in terms of the general comments, like one of the colleagues also indicated, there's some drafting and language errors that we've also picked up throughout our common section, common document. Then also there's a few definitions that also needs to be made, just definition in terms of parliament. Within the definition, can we also just, the drafters please include or reference is made to the Portfolio Committee on Transport. Then also another question that we need some clarity on. It's unclear why a new bill was prepared instead of preparing an amendment bill that amends the National Railway Safety Regulator Act of 2002. Then also in terms of this bill, it is proposed that formal agreements is made between some of our national heads like Transport, PRASA, SAPS and Metrorail, just in terms of to highlight the roles and responsibility, and then also including roles and responsibilities for operators. Then I'm going to go into specific comments or specific provisions that we made. Then in terms of clause 1, various definitions should be considered, like republic, operator, persons with disability, technology. Then in terms of clause 3, it's recommended that the new paragraph be inserted to state the following: ensure the safety of rail passengers and rail infrastructure through the deployment of security at key infrastructure to combat vandalism, theft, property safety from harm to the person or property of commuters and staff. Then in terms of clause 4, specifically exemption from the Act, the clause is lacking that it's not prescriptive in terms of what qualifies a criteria for exemption. So that is just something that needs to be looked at. Then also in clause 4, it speaks to about the reasonable time. We should also just highlight to National to maybe indicate a specific time frame that may be extended by the minister. It should also be mandatory for a minister to publish this in the Government Gazette for comments. Then also it lacks transparency in terms of the decisions that the minister can make in terms of suspension, withdrawal, and amendment of the exemption. Then in terms of clause 7, functions and powers of the regulator, amend the clause to address the interventions that are necessary to combat, like I said earlier, vandalism and the destruction of infrastructure. I think this comment, clause 9, as far as possible, was indicated by one of the colleagues. Then also in terms of clause 9, the term railway environment, sometimes we refer to that in terms of operational conditions and not the business or the industry sector. So we recommend that rail environment be changed to railway sector. Then clause 18, committees of the board. It's unclear what the bill indicates as appropriate person. The recommendation there is to recommend that the clause stipulates the particular criteria for skills and expertise for that specific person. Then in terms of the composition of the board, it is recommended that one of the members should have knowledge and experience in policing, security, and law enforcement, just to up that that discussions or the safety issues with on the board. It is recommended that representation from the Department of Public Enterprises is also included on the board of the regulator. Then in terms of clause 11, appointment of board members, the use of the word must could potentially create implication that the minister is under obligation to appoint all potential candidates for board membership. Minister must have the choice to appoint or not. So just in terms of appointment there, it's unclear whether the intention of 30 days applies to the appointment of individual board members or all the board members. So just a recommendation there is to use clear language within that specific clause. Clause 12, in terms of the chairperson and deputy chairperson of the board, it's unclear if the chairperson and deputy chairperson may only be chosen from the non-executive board members. We gave the recommendation there that the wording should be revised for clarity. It is also unclear what is intended by the word vacant.
It came back again, but
okay.
now I don't know.
I'll just continue. Vacant, as it basically can imply that the person is no longer in a position. So we just need to highlight if the intention there is to refer to temporary incapacity or unavailability. Then a notice period for a chairperson or deputy chairperson to vacate his or her office is not included within that specific clause. Then I'll move on to clause 13, the term of office and conditions of service board members. Review the intended meaning of executive and non-executive board members. And then also just that it reflects throughout the bill where it's applicable. Then clause 14, functioning of a board. The board should also develop strategies and plans to secure the rail infrastructure, thus promote safety for all rail commuters. In disqualification from appointment as a board member, immediate family member, we unclear on what that constitute. Then meetings of the board, it is proposed that board meetings to be held at least once every quarter. The committees of the board, appropriate person is also unclear. It just needs some more flesh to that, or yeah. Then dissolution of the board to strengthen the Parliament's oversight role. The minister must not just inform Parliament of the appointment of the board, but also when he intends to dissolve the board. Within that clause also, it's unclear who may be appointed as an administrator. Then in terms of clause 22, in terms of the CEO, the recommendation there is that the minister must also base sorry, I'm just breaking up here. could be worth including board participation in the setting of terms and conditions of the service for the CEO within that specific clause. And then there's a phrase within that clause, the due process of law is also vague. Then in terms of the functions of the CEO, it's recommended that the qualifications that the acting CEO should be an employee of the regulator, that needs to be removed, as it will allow for flexibility to appoint external parties as the acting CEO. And then all strategic documents or policies is also based that specific phrase under the functions of the CEO. Then clause 5 is a bit of a concern for us. It is a great concern that in terms of clause 25, the boldest state and other associated entities are not liable for any loss, damage, or failure to exercise any power or perform any function in terms of the bill. I just wanted to highlight that. So there's no measures in place to hold the regulator accountable. And then also the expression performance of any function in good faith does not assist in terms of the statements that is made there. Clause 30, in terms of safety permits, the safety permits need to put privacy in various media to reach a wider audience. Then the conditions of safety permits, it's not clear why additional safety permits conditions must be unique to a person submitting the application. Just clarity on that specific conditions or clause that is made. Clause 32, amendment of conditions of the safety permit. It's also not clear if the initial decision is taken by the board or the regulator. Then in terms of clause 33, the surrender, suspension, and revocation of safety permits. It's also unclear when a permit should be revoked. Then in terms of clause 35, evaluation and registration of training institutes, we also made a comment there to consider whether there are opportunities to use the Sector Education and Training Authority. Then in terms of raised railway safety standards, if the intention here is that it is in the form of regulation, then it needs to be published by the minister and not the regulator. Then also there's some unclarity, or there's no clarity in terms of the difference between a railway safety standard and railway safety specifications, if there's any difference. Then the consultation forum, it's unclear what type of matters the forum will consider. Then also there needs to be specified in terms of on which level this consultation forum will operate. Will it be on provincial level? Then in terms of the clause 41, railway safety inspector, whether the safety inspector will operate similar to a sub-director within a regional office. And then also details are lacking in terms of the functioning and administration requirements of this specific office. Clause 42, powers and duties of railway safety inspector. It may be useful to put in general protocols for this to be included with an operator, routine compliance. We've put some case law there because some of the phrases is very wide, so that there's just consistency in terms of the routine compliance inspections. Enforcement inspections, the same for national, just to look at that specific case law. Clause 44 should be reconsidered to ensure there is consistency with application in case law on searches under authority of a warrant, what I just mentioned earlier. Clause 45, formalities of inspections. It's recommended that the clause be revised to make provisions for cases in which certain people may not identify as male or female, because we're living in a non-binary type of, there's people that basically don't identify as male or female. Clause 44, for the formalities of the inspections. It's typically recommended here that the clause be deleted. Then clause 47, powers of railway safety inspectors to deal with unsafe conditions. It's unclear what is meant by conditions and activity. Then in terms of clause 48, railway occurrences, it's not clear what is meant by infrastructure which has a direct or indirect bearing on railway occurrences. The recommendation there is just to look at the wording to clarify that, so that we are certain in terms of what is intended under that clause. Then referring to infrastructure that has an indirect bearing on railway location, it's very wide and open to interpretation, and it could lead to unintended consequences. So just again, the phrase should be narrowed in terms of that. Major investigations. It is recommended that the wording be revised to afford the minister the discretion to request interim reports from the investigators. This should be in addition to the investigator being afforded the discretion to submit interim reports. To reach a wider audience, we just propose there that the final report be published in the Government Gazette. Then in terms of standard investigations, the words must conduct an individual investigation, but confusing. The phrase might be misinterpreted as they should conduct one or combined investigation. Then in terms of clause 35, appeal to board appeal committees. In certain circumstances, it's unclear whether or not the intention is referred to the board or the board appeals committee. So just clarity on that, or just be very clear on where this appeals must go. Appeal to board appeals committees under 55(3). The subsection doesn't make provision for instances in clause 54(6) where the appeal was lodged directly with the board appeals committee. Then also in terms of clause 55, appeal to board appeals committee, this clause suggests that the standing board appeals committee will be chaired by a member of the board and two other persons, which doesn't appear to be correct. Just for National to look there. In terms of our interpretation, the intended meaning seems to be that the appeals committee is chaired by a member of the board and that there are two other persons who are members of the appeal committee and they are not co-chairs. I'm on the last slide. In terms of clause 61, regulation and notices. The phrase any other place as a station is not clear. It basically assumes or that it refers to the designation of any other place as a station. However, this would be clearly stated. Consider amending the clause to provide electronic submissions also. Then traditional railway operations and rapid rail operations should also be included in your definitions. Clause 66, notice regarding fees. The bill states that the minister may determine the permit fees in consultation with the Minister of Finance in terms of annual fees. Then what we propose there is that the determination of fees should also include consultation with our railway operators. It is recommended that the proposed fees be published for public comment. Thank you, Chair. Thank you, colleagues.
Thank you, Mario.
Thank you, Mr. Brown. Mr. Makaepia, any comments from your side that you'd like to make? If you wish.
Thanks, Chair.
Yep.
We are obviously seeing the comments for the first time. And if the committee wishes us to provide a response, we will do that in writing, Chair.
Okay, great. Thank you.
You can share the comments with us.
Yeah, thank you, sir. Much appreciated. From any of our colleagues on the platform, if you have any questions of clarity you'd like to pose to Mr. Brown. If none, thank you, Mr. Brown, for the presentation. Ms. Moore, we will proceed with the second bill, and that is the Transportation Tribunal. Please proceed.
Thank you, Chair. Just flight the presentation. Chair, so the comments are on the Transport Appeals Tribunal Amendment Bill of 2020, and the bill is supported. In general, the department was encouraged by the previous recommendations that had been made to a previous version of the bill that had been incorporated, especially some provisions on the consultation process to make it more practical. On the specific provisions, the comments are in the definitions to just continue to include the reference to permits where some provinces might still have those in place. And then also a definition on the board is where we propose that there's a continuous reference to provincial operating license boards where those have not been established or disestablished to create the provincial regulatory entities. So it's just some hangovers from the past that we propose is brought in. Then substantively, the clause 4 proposes to replace the power of the chairperson to determine the time in which a tribunal will sit, and that power is given to the Director General of the department. The comment here is that we recommend that the tribunal retains its independence with regards also to its work. It's not clear why it's been proposed, as the chairperson will be more familiar with the caseloads and the nature of cases, etc., and that in conjunction with its members, it will be more suitable for the chairperson to determine the time for the tribunal to complete its work. We are aware that the Director General, there might be financial implications, so to accommodate that, that the Director General, in consultation with the chairperson, can then finalise the financial implications also of the work programme. In clause 5, there is a reference to relevant transport legislation, and we are just asking that that is expanded to both national and provincial transport legislation. In clause 7, the Chair, this is also just a matter of substance. The practice is that where there is an appeal, the outcome of a decision that is being appealed is suspended. So there's provision for an automatic suspension of the decision or the direction on which the appeal is lodged. The concern is that where there might be an implication on on the applicant that there is provision for exceptional circumstances in which the applicant can then utilize those as procedural tool to argue against the automatic suspension of a decision. So where it is in the interest of the applicant for the original decision not to be suspended, that there is provision made in case there might be some prejudice against the applicant. As indicated earlier, Chair, the concern with regards to the independence of the tribunal also arises in clause 4. The powers given to the Director General, in this case again, to carry out any investigation requested by the tribunal that is necessary for taking decisions without the need for the tribunal is the concern. So I think the amendment bill deletes the consultation requirement, and we are arguing that to retain the independence, the tribunal must be consulted on these outcomes. They are ultimately will be affected by these decisions. They should the investigators' powers must therefore be independent of the executive. And that it is necessary for the operational reasons of the Department of Transport, they can be designated to carry out such investigations, but it must be after consultation with the tribunal. And therefore that is proposed. It is also proposed that section 16 be expanded to allow the tribunal to request the Director General to perform these investigations. So both the consultation with and the provision for request of these investigations is proposed. In section 4, clause 2, the bill, the scope of the bill is expanded in clause 2 to include the proposed amendments to provide for the invitation of the public to nominate people to the or members of the tribunal. And we are asking that those nominations or invitation to nominate is circulated more broadly. Currently, it's provided for national and for each of the provinces. We are saying that it should also be no, it is only saying the media. We are asking that it would also be nationally and in each province. Apologies, Chair. And then in terms of section 6, we are proposing that the limitations on appointment to the board is just completed in terms of its scope. In terms of other legislation, is to prevent a minor or a person of unsound mind to be appointed, in addition to what is already provided for. Then the conflict of interest issue that is provided for in section 10 is that it is proposed that it is amended to provide that a member must not attend or take part in the discussion of a decision of any matter before the tribunal in which he or she or his or her spouse or relative within a second degree of affinity or his partner or his employer other than the state or the partner or employer of his spouse has any direct or indirect pecuniary interest. So it's just to expand the relational impact for which a member should recuse themselves. In section 16, we are recommending that additional section 5 and 6 be added, and that would be for the Director General to report on the activities of the tribunal and for that report to be tabled by the Minister in Parliament. Those are the comments. Thank you very much, Chair.
Thank you so much, Ms. Moore. Right, colleagues, any questions for clarity you'd like to pose? Well, I see no hands. So could I ask the legal advisors on, whether they have any possible matters that they would like to flag? Ms. Kuele, please proceed.
Thanks so much, Chair. I would like to, there are two issues that I would like to flag, and they've previously touched on it in the presentation by Ms. Moore, but I just want to now emphasize from a legal perspective and a constitutional law perspective when it comes to the amendment or the removing of the words after consultation with the tribunal. So, Chair, as mentioned previously, the objective of the tribunal is that it must be impartial and perform its functions without fear, favor, or prejudice. So, in the Principal Act, the words must are pre-entry, and it shows that there's an obligation on the tribunal to discharge those duties impartially. So, by removal of the words after consultation with the tribunal in the intended amendment will possibly not cause constitutional muster, because when a court would apply the rationality test, there would have to be a rational link between the objective of the act and the intended amendment. And if the intended amendment compromises the impartiality of the tribunal, then it would not it will not pass the rationality test, and in turn it will not pass constitutional muster. And then the second issue that I want to raise, Chair, is within that amendment, the words and to perform any investigation required by the tribunal that are necessary for taking of its decision. Now, within the Act and within the bill, there is no contextualization of what is exactly referred that investigation, the word any investigation. When this provision is interpreted, they will look at the language used, using the ordinary rules of grammar. They'll look at the context which a provision appears. They'll look at the purpose which it's directed. And I'm of the view that the provision does not provide sufficient particularity, and it's goes too wide. It does not appear expressly in the Provisional Act and in the Principal Act and in the bill, the context in which the provision appears. And nowhere does it appear expressly the subject matter of those investigations and the scope of those investigations. So anybody reading this act, and if judging to interpret the act, they have to draw certain inferences which may lead to the incorrect interpretation. And those are my views. Thanks, Chair.
Thank you so much, Ms. Kuele. Any responses? Ms. Kuele, could I ask that you perhaps formulate that response and then send it on to Mr. Kutsi, and then we see how we can incorporate it within our negotiating mandate to be presented to the NCOP. Would that be okay?
Certainly, Chair. I'll do so.
Thank you so much, Ms. Kuele. Right, Alex, any last opportunity if you'd like to pose any other questions for clarity? If not, in the absence thereof, allow me the opportunity to ask if the minister is still on the platform. If you'd like to say a word or two. Minister Mackenzie, are you on the platform?
Yes, Chairperson, I am.
Good.
Can I just say thank you very much, Chairperson, for the meeting and for the presentations. It was great listening in. And obviously, we want any rail regulators to make our trains as safe as possible. We all love trains in the country, and we want them to be safe because we enjoy seeing the trains running. So this is very important to us, and I know it's very important to them as well. So Chair for inviting us to be able, it was great listening into the conversation and hearing what some of the challenges and the concerns are and how we can potentially address these. So thank you for that.
Thank you, Minister Mackenzie. Allow me the opportunity to thank our colleagues from the National Transportation Department, Mr. Makai Pia and his team, and of course, Ms. Moore and her team from our Mobility Department. Colleagues, we will have a brief break just to allow you to arrange a cup of tea or any other comfort break, and then thereafter we will reconvene. The officials, if they wish to rejoin us or stay, they are most welcome, but they're also able to, if they wish, to exit the meeting. And from all of us, I would like to extend our heartfelt thank you to the hard work and the thoughtfulness that went into the presentations and the presence here. But there is a hand before I adjourn this meeting briefly. I see Mr. Matsubele, he said, well, let me see who's there. Okay.
Thank you, Chair. Can you hear me?
Yes, I can hear you loud and clear.
Thank you, Chair. I am Advocate Zongezile Mongezi Matebese from the Department of Transport.
Okay. Thank you.
Responsible for the Transport Appeal Tribunal Amendment Bill.
Okay, thank you.
Yes, Honorable Chair, I heard everything said, and I would love also to make a request therefore that if the department has to respond to the comments on the Transport Appeal Tribunal made bill, I think we'll request therefore that we finish with the same so that we can engage with them on a written format. Thank you, Chair. And
thank you so much, Advocate Matebesi. It's just just the difficulty we have, and if it is dispatched to you today, is when will we be able to get the response back? Because the negotiating mandate will be serving it at the NCP on the 13th of March, which is next week sometime. We will get it before the end of the week.
Yes, Chair, before end of the week, you can get a response, Chair.
Great, thank you, Advocate. Much appreciated. With that, colleagues, it is now, what's the time? It's 8 minutes to 3. Can we reconvene at 3 to discuss the negotiating mandate and the way forward? And all the officials, they may exit the meeting, or if they wish to join us after at 3, they're most welcome to do so. Colleagues, thank you for your patience, and we will reconvene at 3. Thank you so much. De Villiers, thank you. Honorable Seleko, thank you. Colleagues, thank you, and welcome back. Now, we have had the presentations on the amendment bill as well as the road safety bill. So let me just get an indication is that after the presentation, then all the questions were raised, a number of issues were raised by the department, but let me just mention that these two bills, as we know, they were advertised on the 7th and the 9th of December last year. They were advertised in the Burger, Week in August, and City Vision. The closing date to submit oral and written submission was on Friday, the 26th of January. We received no requests from any stakeholder or interested parties to make any oral submission. All written comments were distributed on the 21st of February to members for their input and perusal. And unfortunately, we are pressed for time. We're sitting with due dates now for a negotiating mandate for the Transport Appeal Tribunal Amendment Bill on the 13th of March, which is next week. And then also the negotiating mandate for the Rail Safety Bill on the 27th of March. The final mandate for the Transport Appeal Tribunal Amendment Bill is on the 27th of March. So between the 13th of March and the 27th, we will have an opportunity to meet to formulate our final mandate. And to date, there's no final mandate being sort of scheduled for the Railway Safety Bill. So with that, we need to decide now. As I may also add that in addition to the print media advertising, we also advertise on social media. We advertise on Facebook and X and Instagram, and we have reached with the Railway Safety Bill over 117,000, almost 118,000 individuals or users or followers. Similarly, with the Transport Appeal Amendment Bill, we reached over 142,000 potential users. So as you know, as you can see that we have sort of advertised widely, and the responses have not been very sort of significant. We received responses from the City of Cape Town on the Road Safety Bill, and that also were distributed to members. So as you also now aware that the department, the National Department, will provide us with responses insofar as the matters raised by the Department of Mobility. So we have time to wait for the responses on the issues raised, because the negotiating mandate is only to be served on the 27th of March. But in terms of the rail, the Transport Appeal Tribunal, Mr. Matabesi, Advocate Matabesi, stated that he will respond by end of this week. So initially, the whole purpose of this meeting also was to formulate the negotiating mandate, but it is my view that the matters raised, including that by Ms. Coelho in terms of issues that she's identified need to be considered when we formulate our negotiating mandate. So my proposal, colleagues, and you could provide guidance, is that we suspend the formulation of any negotiating mandate at this stage. I know we are pressed for time, but the urgency of the tribunal mandate is imminent, and we, by the end of the week, as Advocate Bessie stated, you will revert back to us. So we could possibly then meet early Monday morning if it is convenient to members, and formulate that negotiating mandate. And once we have received the feedback from the National Department as far as the Railway Safety Bill is concerned, and then we can, meet and then formulate the mandate for the 27th of March. Please advise, and how are you feeling about that? The floor is open for comments. Honourable Father Bessie, I recognize you.
Yes, thank you, Chairperson. Chairperson, I concur. Certainly, the department should be given an opportunity to respond to the comments that we've received, including that from the Western Cape government. And therefore, I think I concur with your thinking and proposal of the way forward. If I could just ask that if we should consider a meeting on a constituency day, that be indeed, again, a virtual meeting which would allow us to join from our constituencies. Thank you.
Yeah, thank you, Honourable Van der Westhuizen. Certainly it will be virtual, and it will not be in person. Thank you. Any other comments? So the way forward is that when we do meet, and that's possibly Monday morning or whenever Johan and I can determine appropriate time, we will let members know. It will be for no longer than 30 minutes or no longer for an hour, put it that way. And then it will only be for the purpose of formulating our negotiating mandate for the Appeals Tribunal Amendment Bill. So, in principle, the department support the bill, but certainly we need to incorporate whatever elements within our mandate that could possibly be considered for a final mandate to be formulated. Any other comments, colleagues? We will notify members in good time once we have secured a time, and then we could ascertain whether that would be an appropriate time for us to meet. Allow me to thank you for your patience and being present in the meeting, and for your inputs. Thank you to our legal advisors from the Premier's office, Ms. Muller and Ms. Syria, as well as Ms. Kuile for your input, and to our administrative staff, support staff, Ms. Mshimpele, as well as our IT staff, and of course, certainly our members for being present. And of course, lastly, to Mr. Kutse for his support. Colleagues, with that said, the meeting is adjourned. Thank you so much.
Thank you.